Good morning again, ladies and gentlemen. We're back in dockets number 2021-89E and 2021-90E, Duke Energy Progress, LLC, and Duke Energy Carolinas, LLC, 2021 avoided cost proceedings. Let's take roll. Present in the hearing room, we have Commissioner Powers, Commissioner C. Williams, Vice Chair Belzer, Chairman Williams, and Commissioner Thomas. Joining us virtually, we have Commissioner Irvin and Commissioner Caston. So we're back on the record in this proceeding. We've heard the oral argument from ORS and the other parties' comments. We've made our decision in the special business meeting. I'm going to ask the applicant to call their first witness. Well, I'm sorry, let me pause. I did not see or hear any request for opening statements. Do the parties wish to make opening statements?
Mr. Chairman, members of the Commission, Brett Bryce on behalf of the Duke companies. We do not plan to make an opening statement on behalf of the Duke companies this morning.
Thank you,
Mr.
sir.
Chairman, Mr. Chairman, this has been Mushin on behalf of ORS. We also do not plan on making an opening statement.
All right. If no party plans to make opening statements, Attorney Brightsworth, if you would, please call your first witness. Now, I need to make a point here. If the witness is testifying in South Carolina, our court reporter is happy to swear the witness in. If the witness is testifying outside of the state, I will swear the witness in. So, counsel, if you would let us know if your witnesses are in state, and if not, then I need to swear them in. Thank you.
Thank you, Mr. Chairman. And both Mr. Snyder, who will be testifying first, as well as Mr. Johnson, who will be testifying second on behalf of the Duke companies, are both testifying from Charlotte, North Carolina, so they are outside of the state. So I would ask that if you would please swear in Mr. Snyder and then Mr. Johnson, that would be helpful. But before we, I think Mr. Snyder's called to the stand at this point. Before we get started, maybe just to kind of lay out the company's plan for the presentation of its case to the commission. We spoke with Ms. Westinger Hill and the parties this morning, and the Duke companies plan to have the direct testimony and stipulation testimony of Mr. Snyder, present that testimony, followed by the direct testimony and stipulation testimony jointly of Mr. Johnson. In light of the commission granting the hydro interveners a request to withdraw their intervention from the case, the companies did not plan to present their rebuttal testimony in this proceeding, as that was directly responsive to rebuttal testimony that's now been withdrawn as part of that withdrawal of the intervention. So just wanted to apprise the commission of that at the outset. And the one other procedural request before we commence with Mr. Snyder is that the stipulation of agreement filed on July 23rd, 2021 on behalf of the Duke companies, CCBA, SACE, CCL, and Office of Regulatory Staff will be supported jointly by both Mr. Snyder as well as Mr. Johnson's stipulation testimony. And so if I could, Mr. Chairman, just make that the first hearing exhibit in the record, I would appreciate starting there before having Mr. Snyder sworn in.
Absolutely, sir. The first exhibit will be the stipulation between the parties that will be entered into the record as hearing exhibit 1.
Mr. Chairman, this has been Mushin with the Office of Regulatory Staff. Just from a technical standpoint, first, we appreciate the commission allowing us to represent our witnesses at the September 16th hearing. So thank you for that. With respect to the stipulation, we of course have no opposition to it being entered into the record. I did just want to note that that would be subject to any findings that the commission's consultant may have if there is some new issue. We do not anticipate that being the case. We do not anticipate there being anything new, but in the event that there is, we would like to be able to address that at the September 16th hearing.
Noted. Thank you, sir. And Attorney Brightsworth, before you begin, just wanted to let everyone know that we will take our afternoon lunch break at 12:30, and the plan is to go no later than 6 p.m. today.
All right, thank you, sir. The companies call Mr. Glenn Snyder to the stand.
Mr. Snyder, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, sir?
Yes, I do.
Thank you, sir.
Thank you. Good morning, Mr. Snyder.
Good morning.
Would you please state your full name for the record?
Yes, my name is Glenn A. Snyder.
And by whom are you employed in what capacity?
I'm employed by Duke Energy as Director of Carolina's Integrated Resource Planning and Analytics.
And Mr. Snyder, how long have you been employed by Duke Energy and working on matters related to PURPA?
I have worked for Duke Energy or one of its predecessors since 1992. I'm not an attorney, but I have become familiar with Section 210 of PURPA and FERC's regulations implementing PURPA through my role at the companies, and have testified multiple times before this commission and the North Carolina Utility Commission on PURPA avoided cost issues.
Thank you, sir. And did you cause to be pre-filed in this docket direct testimony consisting of 30 pages?
Yes, I did.
And do you have any changes to that direct testimony at this time?
No, I do not.
And if I were to ask you those same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Thank you. Mr. Chairman, at this time, I'd ask Mr. Snyder's pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Snyder's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you. Mr. Snyder, turning to your exhibits, did you also cause to be pre-filed Snyder DEC Exhibit 1 and Snyder DEP Exhibit 1, as well as DEC DEP Joint Exhibits 2 and 3, totaling 30 pages with your direct testimony?
Yes, I sponsored those exhibits in support of my testimony.
And your DEC Exhibit 1 and DEP Exhibit 1 respectively included confidential information which was pre-filed under seal, is that right?
Yes.
And do you have any changes to those exhibits today?
No, I do not.
Thank you. Mr. Chairman, at this time, I would ask that Mr. Snyder's DEC Exhibits 1 and DEP Exhibit 1, as well as the joint DEC DEP Exhibits 2 and 3, be marked as the next composite hearing exhibits, and the confidential information in the DEC Exhibit 1 and DEP Exhibit 1 be maintained under seal.
Snyder DEC Exhibit 1, DEP Exhibit 1, DEC DEP Exhibit 2, and DEC and DEP Exhibit 3 will be marked as a composite exhibit and entered into the record as hearing Exhibit 2 with the confidential portions of Snyder, it's 2, right? With the confidential portions of Snyder DEC 1 and DEP 1 to remain under seal.
Thank you, sir. Mr. Snyder, turning to your stipulation testimony, did you also cause to be pre-filed in this docket additional stipulation testimony consisting of 5 pages?
Yes.
And do you have any changes to your stipulation testimony at this time?
No, I do not.
And if I were to ask you the same questions today that appear in your pre-filed stipulation testimony, would your answers be the same?
Yes, they would.
Thank you. Mr. Chairman, at this time, I'd ask Mr. Snyder's pre-filed stipulation testimony be entered into the record as if given orally from the stand.
Mr. Snyder's pre-filed stipulation testimony will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. Snyder, just to confirm, you did not have any exhibits that you pre-filed in support of your stipulation testimony, correct?
No, I did not.
All right, thank you. Mr. Snyder, I'd now like to walk you through a brief summary of your direct and stipulation testimony and to present that, ask you to present that summary to the commission. I'd like to start with your direct testimony, if I could, please, and have you provide a general description of the purpose of your testimony as discussed on page 5 of that direct testimony.
Yeah, the purpose of my testimony is to support the company's implementation of the requirements of the PURPA and the PURPA-related sections of Act 62, including the methodology for calculating avoided cost rates paid to qualifying facilities, or QFs, pursuant to these state and federal laws. More specifically, my testimony provides recommendations relating to the fair, just, and reasonable calculation of avoided capacity and avoided energy costs used to compensate QFs under the company's standard offer purchase power tariffs and large QF tariffs.
Thanks, sir. And then on pages 6 through 11 of your testimony, you provide the commission an overview of Act 62 as it relates to South Carolina's implementation of PURPA. Can you please summarize that testimony for the commission?
Yes. My testimony explains that Act 62, Section 48-41-20, subsection A, requires the commission on a biannual basis to approve each electrical utility's PURPA implementation framework. Specifically, this includes utilities' avoided cost methodology and the contracting documents used when transacting with small power QFs under PURPA. The requirements for the commission set out in Act 62 do not change well-established legal standards and requirements for quantifying a utility's avoided cost. As my testimony explains, Section 210 of PURPA rests on the twin pillars of non-discrimination and customer indifference. Specifically, Section 210 of PURPA requires that the price paid to utilities for must-take purchases of QF output be just and reasonable to the electric consumers of the electric utility and in the public interest, and not discriminate against qualifying cogenerators or qualifying small power producers.
Thank you, Mr. Schneider. And can you explain the methodology that DEC and DEP each use to calculate avoided costs under PURPA as you addressed on pages 13 and 14 of your testimony?
Yes, I can. DEC and DEP have consistently used the peaker methodology to forecast the company's avoided cost of capacity and energy in order to set the avoided cost rates paid to QFs. The peaker methodology is a widely used and accepted industry approach to quantifying avoided cost. It provides an appropriate and reasonable estimate of the avoided or incremental costs of alternate capacity and energy that would have otherwise been incurred but for the purchase from a QF facility. As such, the peaker methodology appropriately leaves the consumer indifferent to the utility's required purchase of QF generation relative to the utility's own generation.
Thank you. And can you describe in more detail how the avoided capacity costs are calculated under the peaker methodology?
Yes, I can. The peaker methodology calculates avoidable marginal capacity by examining the annual fixed costs associated with constructing, financing, and operating a simple cycle combustion turbine, often referred to as a CT or a peaker unit. The avoided cost calculation takes into consideration the utility's actual need for capacity based on customer demand. Specifically, the avoided cost calculation considers at what point in the future the utility's most recent IRP projects a need for avoidable capacity. DEC's projection of its first avoidable capacity need arises in 2026, while DEP's first avoidable capacity need arises in 2024. For comparison, DEC's first year of need, 2026, is the same year of need as identified in the 2019 avoided cost proceeding. However, since 2 years have passed, this results in an increase to the avoided capacity rates relative to the 2019 avoided capacity rates due to the fact that the number of years in the updated 10-year period with an ascribed capacity value has increased by 2 since 2019. DEP's identified first year of need, 2024, arises 4 years later than that was projected in the 2019 avoided cost proceeding, which results in a slight decrease in the avoided capacity rates relative to the 2019 proposed avoided capacity rates.
Thank you, Mr. Schneider. Can you please now describe how the avoided energy costs are calculated under the peaker methodology?
Yes, I can. Calculation of avoided marginal energy is determined using IRP production costing models to project marginal cost savings into the future. Marginal energy value is determined by first looking at the total production cost to run the system over the next 10 years. This represents the base case. That base case run is then given 100 megawatts of no-cost generation with all other variables being the same. This creates a change case. The savings produced from the change case containing the 100 megawatts of no-cost generation as compared to the base case without the no-cost generation are expressed in dollars per megawatt hour and grouped into the 9 energy pricing periods identified in the energy rate schedule filed in this proceeding.
Thank you. And in summary, do the company's avoided energy and avoided capacity cost methodology and the calculations of those avoided cost rates and the rate designs used to provide the rates to QFs adhere to the requirements of PURPA and the Commission's orders in the 2019 avoided cost proceeding? That was the first proceeding under Act 62.
Yes, they do.
All right. I'd now like to turn to your stipulation testimony, please. Could you summarize for the Commission, in general terms, the stipulation reached between DEC, DEP, ORS, CCEBA, SACE, and CCL, please?
Yes. For ease of reference, I'll refer to each of the parties you just mentioned as the stipulating parties. In short, the stipulating parties agree to and recommend the Commission approve the company's proposed avoided cost methodology and calculation of avoided energy and avoided capacity rates for DEP. For DEC, the stipulating parties agree to and recommend the Commission approve the company's avoided cost methodology and avoided energy rates. The stipulating parties support one adjustment to DEC's avoided capacity rates to adopt the position presented by ORS witness Brian Orey on the seasonal allocation of capacity value.
Thank you. Can you describe in a little more detail the seasonal allocation of capacity value issue that you address in your stipulation testimony?
Yes, I can. The companies incorporate a seasonal weighting in their avoided capacity cost calculations to appropriately recognize the season of the year that drives the company's reliability need for new capacity additions. For DEC and DEP, the seasonal allocation is heavily weighted to winter based on the impact of summer versus winter loss of load risk, which is driven by volatility in winter peak demand, as well as the growing penetration of solar resources and its associated impact on summer versus winter reserves. In developing these seasonal weightings, the company used the 2018 solar capacity value study. Based on that study, DEC's seasonal allocation is 89% winter and 11% summer. ORS witness Orey direct testimony recommended that DEC's proposed allocation should be adjusted to 95% winter and 5% summer based on results from the DEC 2020 resource adequacy study and to better align with the current levels of solar on the DEC system. The stipulating parties agree to ORS witness Orey's recommended adjustment for purposes of calculating DEC's avoided capacity cost rates in this proceeding.
Thank you, Mr. Snyder. So in the company's view, does the stipulation reached by the stipulating parties result in avoided energy and avoided capacity cost rates for both DEC and DEP that are reasonable and consistent with the requirements of PURPA and Act 62?
Yes, they do. I believe the stipulation represents a just and reasonable resolution of the issues in this proceeding and results in avoided energy and avoided capacity rates that are reasonable and consistent with the requirements of PURPA and Act 62.
Thank you, Mr. Snyder. Mr. Chairman, Mr. Snyder is now available from questions, 4 questions from the parties and from the Commission.
All right, thank you, Attorney Brightsworth. I want to make sure I have our procedure right, and I understand what we're doing here. My understanding is that the parties waive cross-examination to these witnesses.
Yes, sir. All of the stipulating parties did waive cross-examination, and the one non-stipulating party in the case, which is Johnson Development Associates Counsel, Mr. Adams, filed a letter last week saying that he did not have any cross-examination for these witnesses, and I believe he can speak for himself, but I presume that ADA has no cross.
That's correct. Yeah, that's correct. Just Weston Adams here. We will not have any cross for this.
Okay, so the only questions will come from the Commission, correct?
That's my understanding of procedure. And I also know that I see Mr. Hall has appeared on the screen, so I'd let him speak for the consumer advocate.
Yeah, thank you. I was just going to clarify that the department is not one of the stipulating parties. We did not object to the stipulation, and we also, though, do not plan to ask any cross-examination questions.
All right. So all we have here are questions from the commissioners. Commissioner questions. Commissioner Powers.
Mr. Chairman, just one quick question. Mr. Snyder, in your testimony on page 9, you talk about that the companies have under contract 4,700 megawatts of QF PURPA power in North and South Carolina. How much of that is South Carolina? Just roughly.
Howard, I do not have the breakdown in front of me with North and South Carolina. Perhaps witness Johnson that testifies after me may have that breakdown for you, sir.
Okay, thank you.
Vice Chair Belzer.
Thank you, Mr. Chairman. Good morning, Mr. Snyder.
Good morning, Commissioner Belzer.
Thank you for your testimony this morning. My question goes to the allocation and in the stipulation, the stipulating parties agreed to adopt witness ORE's seasonal allocation in DEX territory. And I understand that in the application, is it correct that the Duke companies relied upon a 2018 solar capacity value study in preparing the application?
That's correct, Commissioner.
But witness ORE recommended using the 2020 resource adequacy study from the IRP. Is that correct?
That is correct.
Okay. How are those studies similar? Do they provide similar results? I mean, I know what the numbers are that they've provided, but are they looking at similar points and aspects of the system?
Yes, they are, Commissioner, and it really is looking at what impact solar has, how it's changed over time, along with peak demand volatility in the winter that we see that's just not quite as strong as the volatility in the summer. And those two factors together, both the studies look at loss of load probability and how much of that occurs in the winter versus how much occurs in the summer. And what it attempts to do then is to ascribe capacity value to where you have the highest loss of load risk, which is in DEP exclusively winter and nearly exclusively winter in DEC. We've been trending towards stronger and stronger winter. And so the update from 2018 to 2020 is just about a 6% adjustment from 89% loss of load risk happening in the winter to 95%. And witness ORE found that more appropriate. And so we agreed with witness ORE that that's certainly consistent with the 2020 study and consistent with the trends we've been seeing for a number of years.
Well, could you tell me why the Duke companies would have used a 2018 study versus a 2020 study for these 2021 avoided cost? Why not?
Yeah,
why would they not have used the more updated study?
Certainly, Commissioner, it's a good question. And, you know, we had that discussion. The 2018 study, again, as I spoke to, that loss of load risk, one of the drivers of that is the penetration levels of solar on the system. The more solar you have on the system, the more that moves you towards that winter. The 2020 study didn't look at a level of solar. It was for reserve margin planning. It really wasn't for seasonal allocation. And so it didn't have the exact levels that lined up as well as the 18 study with the current conditions on the system. And so we were being a little bit conservative in saying, since we didn't have the level of solar represented in 2020 as granular as we did in 2018, we would continue to use the 2018 study. What Witness Ori did, and we thought his approach was reasonable, is he used actually both studies. So he used the 18 study and developed a relationship of how that factor changes with different penetrations of solar. And he then applied that in sort of an interpolation point to the 2020 study, so that even though we didn't have the level of solar studied in 2020 that was commensurate with the current conditions on the system, it was more of a forward-looking. Witness Ori was able to use an interpolation technique from 18 and apply it to 20. And that's what drove that 6%, that small adjustment from summer to winter. And when we reviewed his interpolation technique, we found that to be reasonable and appropriate, Commissioner.
I appreciate that explanation. Thank you. I actually think I followed you, so thank you very much.
Well, that was a lot of words, so I'm pretty impressed that you did.
Well, maybe I followed points of it. Can you tell me the impact of that 6% change? What did that do to the capacity values that were agreed to in the deck, in the stipulation for the deck capacity cost?
So, as I understand it, and I'm sure Mr. Breitschwert will correct me if I state this wrong, to be clear, the stipulating parties also agreed to Witness Ori's small correction there, and the annual capacity value did not change. It just took 6% of that total annual value and moved it from late afternoon in the summer, that 6%, to the early morning winter. So a QF that was providing energy in both those hours would get the same annual capacity payment. It just put a little more weight on the winter. So the total annual value didn't change, but how it got paid moved just a little bit from the summer to the winter.
Okay. And I do recall in your testimony that you just used the phrase "how it got paid." Can you explain that to me on the allocation?
Certainly. So when you come up with an annual value for capacity, you apportion that first into the seasons and then into the hours. So you take a total annual capacity value for the avoided peaker on a levelized basis, again, accounting for that first year in need. You put it into the winter and summer season based on that allocation factor we were just discussing. And then we look at, and I think Exhibit 2 of my testimony sort of shows some of the LOLH hours. So it's basically the loss of load hours that you're likely to have a capacity need. So that seasonal value then gets put into those hours that are defined in the capacity rate, and then divided by the number of hours in that period, so that you can come up with $1 per megawatt hour or a cents per kilowatt hour. So it's just a series of stepping from a nominal to a seasonal to an hourly and putting it on a rate basis that does that. So when you start with that annual, we're now, instead of putting 89% in the winter, per Witness Ori's recommendation, we're putting 95% in the winter, and then it gets allocated into those winter morning hours that are identified in our capacity rate schedule.
Okay. Thank you, Mr. Snyder. Appreciate your attention and responses to my questions. Mr. Chairman, that's all I have.
Thank you, Commissioner.
Chairman Williams.
Commissioner Caston.
I guess listening to your responses to Commissioner Belzer's question, Vice Chair Belsher's question. How, how, um, how will that affect the typical small and large QF? um, by the changes, maybe in the variable 5-year, 10-year energy and capacity credits?
Yes, so, um, as I responded to the vice chair, it's important to note that the total capacity value from this adjustment will not change. It's just to earn those capacity, you have to be available in the winter morning when there's a capacity need and the summer afternoon. And most of the value in the rate structure, if you see the rates for DEC, is in that winter morning, in those winter morning hours. And so that value just transferred from the summer afternoon to the winter morning. But any QF that provides capacity across those two price periods will be indifferent to that adjustment. Now, if you were only providing in one price period versus the other, then depending on the nature of the QF, you could see a small adjustment. And I will say it's a relatively small adjustment in that capacity rate.
So, any effect, or if there's an effect, or the greatest effect would be, if I'm understanding you correctly, a dispatchable versus non-dispatchable?
Yeah, so if you were dispatchable and could dispatch in the summer across those 4 summer hours that we identified, I use this term hour ending, it's hour ending 18, which is 5 to 6 at night, through hour ending 21. Those are our capacity hours. There's a small capacity payment in DEC, and I think for the 10-year rate, I've got my exhibit 3 in front of me. It's 2 cents a kilowatt hour, 2.04. And then in the winter mornings, hour ending 6 through hour ending 10, it is 6.76 cents. So if you're delivering in those hours, in addition to the energy payment in those hours, you're getting the capacity payment. So depending on the nature of the QF and their ability to deliver from hour ending 6 through hour ending 10, they will get that portion of the capacity, and then the same for the summer, but that's a summer afternoon.
All right, thank you, I understand, and I meant to wish you good morning. Good to see you again, thank you.
Good to see you again, Commissioner.
Chairman Williams?
Commissioner Williams, you have the floor, ma'am.
Thank you. Good morning, Mr. Snyder. My question has to do with changes between the previous avoided cost and what's being requested now. And for deck and for the summer peak, it looked like the morning peak had been eliminated, and I just wondered, what the cause for that was.
Yeah, Commissioner, that's a good question, and I think pull up another one of my exhibits. In Exhibit 3, we show the rates, and then I have a Exhibit 2, and then in that there's a subsection called Exhibit 8. It really is looking at the marginal energy value in the various hours with new inputs, as well as the expected load in those hours. So when load is higher, we dispatch our system in what we call economic merit. So when load is lower, you're using your most efficient, lowest variable cost generation. And then as load increments up, you have to dispatch units that are slightly less efficient. So your marginal cost of electricity goes up with higher load. And so when we design the rates, and it's a lot of science and it's a little bit of art, because you're trying to say which hours have, as we bucket this, which hours have the highest value, the middle, and maybe the lowest value. And so in that rate design, what we selected, and I explained that a little bit in that exhibit, is redefining those hours to based on current inputs, based on the current load forecast, current solar, again, because solar will impact what your marginal unit is. We looked at that, and those had changed slightly as represented in that Exhibit 2 and Exhibit 3 of my testimony.
Okay, the way I listened to that, or what I heard, is that it has more to do with the way that Duke is dispatching and the models are calculated than on what the users are, the patterns of the users' needs.
No, I'm glad you asked that question. It starts with the pattern of the user's needs.
Okay.
So we start with how are consumers and again, on a weather normal basis, year to year, you'll get variations in weather that can change those. But we start with that consumer pattern. That consumer pattern, then we recognize that we're going to have solar that will be meeting some of those needs during certain hours of the days and not others. So we start with what we call our energy demand profile. And then when you adjust that for solar output, that's called your energy demand net of solar, or your energy shape net of solar. And then you take your dispatchable units on your system and you dispatch them in that economic merit to meet that consumer demand net of solar. And then what the rate designs attempt to do is take that net energy demand and bucket them into the premium peak, the peak, and the off peak based on what's the highest, the medium, and the lowest needs net of solar, that net demand on the system.
So going back to kind of the pattern of the user, how is that changing that's instigating this change that's significant enough to me that it is eliminated the morning peak demand in the summer?
In the summer, I think what we're seeing is that when we looked at and again, you're talking about how the energy rates here, right? Because capacity, we've never had a morning capacity rate in the summer. So this is just how we bucketed the energy rates. And I think what, all we're seeing is that when we looked at the new data, and again, with more solar on the system, which can come on in the summer, start to come on fairly early in the summer mornings. And the demand that we're seeing in the mornings is that those didn't rise to a high enough level the way they did 2 years ago. Importantly, we still are, continuing to apply the peaker methodology, the whole framework. And it's a little bit of like air in a balloon. When we eliminate that, it's going into other, it's just how you apportion the balloon into the 3 buckets. The total size of the balloon doesn't change. So, for example, a QF that was producing round the clock would be totally indifferent to the rate design, if that makes sense, because we've just moved some energy value from one period to the other. It's just how do you apportion it and how do you do your averaging? And so we've just seen that period did not rise to being a call, that we shouldn't call that out. There's just not enough differentiation in that period to call that a peak anymore.
Thank you. I'm going to do some more reading and let that kind of sink in a little better, but I really do appreciate the background.
And Exhibit 2 would be a good spot that speaks to that a little bit, Commissioner.
Thank you. I appreciate it.
Yep.
No further questions.
All right. Good morning, Mr. Snyder. How are you today?
Good morning, Mr. Chairman. Good to see you this morning.
Good to be seen and happy that you're here to explain your testimony to us. I have a couple of things I want to discuss with you. I've heard you say several times that the stipulation is just and reasonable. so I don't really want to talk about that. I want to talk about risk and how we can protect ratepayers from risk. Um, and it's my understanding that anytime you're setting avoided cost rates, that there's a risk that ratepayers could overpay for energy. And I may not be stating that as eloquently as you uh, may state it, but I think you understand where I'm coming from.
Yes, sir.
How have you or Duke addressed this issue with the stipulation, the risk of overpayment?
Yeah, I think, you know, the Act 62 and PURPA both recognize that risk. The biggest thing I think that we've seen is not allowing the rates to become stale helps to ensure that you're not that you're mitigating that risk. So filing every 2 years for the small QF rate, and I think in the 19 order, the large QFs, and again, small being the 2 megawatts and under, 2 megawatts and above, we update quarterly. So that periodicity of updating rates and not allowing them to sit for a number of years is one of the primary tools that can help keep rates at the true avoided cost, Commissioner. I'm sorry, Mr. Chairman.
Thank you for that, sir. So, do you notice a trend with avoided costs? Are avoided costs going up, trending downwards, or is there no real trend to determine where we will be with avoided costs, say, in the next 10 years?
Well, certainly avoided costs from 2012, I would say, through 2018, we're on a fairly steep decline for a number of years. And we saw that through a number of proceedings that there was a steep decline for 6 or 7 years. Since 2019, and we last filed the rates, rates have stabilized, and they, you know, the filing over filing changes are much more muted over the last few years than they were in the 6 or 7 years prior to that. So I would say, you know, that stability has been a good thing for the last few years, and maybe made some of the issues that were pretty prevalent in that 2012, 14, 16 time frame be not present quite as much risk as we've seen in the last few years.
Do you think that avoided costs will reach a point in the next 10 years where it's uneconomical for QFs to come online?
That's a really good question, and there's so many variables that impact that maybe I'll just touch on a few briefly. So QFs themselves, and again, I think, you know, we're used to talking about solar, but there's a larger array of QFs out there. They've seen significant technology cost reductions. So you have to look at the development side. Then you can look at the development side net of incentives, whether they're state or federal tax incentives or other incentives that are put into place, property tax, investment tax, production tax credits, and not to mention just a decline in the technology cost itself. So on one hand of the equation, you're seeing development costs net of incentives coming down dramatically. On the other side of the equation, the value they provide can can move up or down with commodity prices, and with saturation. So the more of any individual QF you have, the less valuable the next increment is. So more wind, more solar, more cogeneration, more biomass. As you add more and more to the system, the next increment becomes a little less valuable. So there's so many variables that are moving. Commissioner, it's hard to say whether avoided costs will move in a direction that doesn't allow for further development. I hate to dodge your question, but it really is a function of, do incentives and technology gains outpace the level that's being put on the system and the commodity prices and the variable costs that they're avoiding.
Understood, but it's fair to say it's something the commission should be aware of.
Yes, sir.
And when you talk about saturation, essentially what you're saying, and correct me if I'm wrong, and we'll talk about solar. The more solar that comes onto the system, the less valuable that solar power, or
maybe the less valuable the next increment is of solar. It's sort of the diminishing, law of diminishing returns. That's true of most things, right? As you add more and more to, and I could say the same thing, if I had a need for a simple cycle turbine, that, it might provide immediate and high capacity value, but if I kept adding turbines to the system, those turbines would have lower and lower value for consumers. So I think just about any resource you add to the system, supply side or demand side, the next increment of that particular resource has less marginal value than the increment before it.
do you think the solar market is saturated in South Carolina?
Personally, I do not. I think there's room for the solar market to grow. Again, I think it's a little bit of a complex question depending on what happens with all the variables. Again, the extension, as you very well know, the extension of the ITC helped the solar market. Continued declines in the installed cost of solar will help. If you run into temporary supply chain bottlenecks or blips that might cause that would hurt solar being cost competitive. So there's certainly a lot of moving variables, but I don't think given the ITC extension, the expectation of further declines, I think there's room for additional solar on the system, sir.
All right, Mr. Snyder, thank you for your testimony. Are there any more questions for Mr. Snyder?
Chairman Williams.
Commissioner Caston.
I'm back, Mr. Snyder.
Good to see you again, Commissioner Caston.
I was listening to your response to Commissioner Carolee Williams' questions, and the balloon analogy. I want to make sure I understand what you were saying. Going back to the balloon analogy, I'm assuming that the demand is the demand, which is the volume in the balloon, and if you squeeze the balloon, it's going to go here or there, but the volume doesn't change. So, what are you saying, or did I understand it, that the value of the energy producer is directly related to the ability to provide energy at peak times? Or in other words, if the energy producer, and I think this is what I heard you say, if the energy producer can provide energy over a 24-hour period, during the peak times, that number would be greater. During the off-peak times, it would be lesser. But over a 24-hour period, it would be roughly net zero.
Yeah. That's a good question, and there's, again, two components. There's a marginal energy value, which we bucket into the seasonal periods of summer and winter. We have a premium peak, a peak, and an off peak. And what I was trying to explain, and we're going to hold aside capacity value for a moment, because that's the ability to provide dependable capacity for reliability purposes and avoid capital. But the marginal energy value, we start by saying how much marginal energy value is there from a base load unit, 100 megawatts of free generation. And then the art of how do you then take that value created and break it into these rate buckets. All I was saying is that if you change the hours a little bit, it's simply moving value from one pricing period to another. It doesn't change the overall. So the rate design for energy is how do I design those periods so that QFs are incented to give me energy and they're being compensated at the fair but-for price, recognizing that certain periods are more valuable than others. But if I design those rates slightly different, I'm not changing the overall value a QF can earn. I'm simply sending slightly different price signal to say, I'd rather have a little more in this period versus this. But if I was a QF that was providing around the clock, I would be totally indifferent to your rate design, because no matter how you designed it, that the total balloon, I'm going to get paid for that marginal energy. When it comes to capacity, Vice Chair Belser was talking to, then it's the avoided, that's not the marginal energy. That's not the fuel cost and the variable operating cost. That's the avoided peaker cost. That's the capital itself and the need not to build that marginal peaker. That gets ascribed into either the winter morning predominantly or the summer afternoon, and then put on $1 per megawatt hour. And it's the combination of energy and capacity is what the QF earns.
Okay, I think I follow that. And in essence, peak times pay more, off peak times pay proportionally less.
That is correct.
All right, thank you very much, Mr. Snyder.
You're welcome, Commissioner Cass.
Any redirect?
No redirect, Mr. Chairman.
All right, sir. Mr. Snyder, you can step down from the witness stand.
Thank you, Chairman Williams.
All right. Please call your next witness, sir.
Thank you, sir. The Duke companies call Mr. David Johnson to the stand.
Mr. Johnson, if you could if you could take the witness stand.
All right.
Mr.
Sorry
Johnson.
about that. Okay. Can you, I'm on, right?
Yes, sir, you are.
Okay, thanks.
Mr. Johnson, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, sir?
I do.
Thank you.
Thank you, Mr. Chairman. Good morning, Mr. Johnson.
Good morning.
Would you please state your full name and business address?
My name is David Johnson, and my business address is 400 South Tryon Street, Charlotte, North Carolina, 28202.
Attorney Briceword?
Yes, sir.
All right, we thought we lost you there. Please continue.
I'm sorry. Mr. Johnson, by whom are you employed and in what capacity?
I'm currently employed by Duke Energy as Director of Business Development and Compliance.
Very good. I apologize, Mr. Chairman. I didn't think that was a particularly hard question, but I didn't hear an answer either. So good it was on my end and not Mr. Johnson's. And how long have you been employed by Duke Energy and working on matters related to PURPA implementation and oversight of power purchase agreements?
I've worked for Duke or one of its predecessor utilities or affiliates since 1980. I began my current role in late 2017, and I'm responsible for wholesale power purchase agreements that Duke Energy enters into with third-party suppliers.
And Mr. Johnson, did you cause to be pre-filed in this docket direct testimony consisting of 22 pages?
Yes, I did.
And do you have any changes to that direct testimony at this time?
No.
And if I were to ask you those same questions today that appear in your pre-filed direct testimony, would your answers be the same?
Yes.
Thank you. Mr. Chairman, I would ask that Mr. Johnson's pre-filed direct testimony be entered into the record as if given orally from the stand.
Mr. Johnson's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, sir. Mr. Johnson, turning to your exhibits in support of your direct testimony, did you also cause to be pre-filed exhibits including Johnson DEC exhibits 1 through 6, Johnson DEP exhibits 1 through 6, and Johnson DEC DEP joint exhibits 7 through 10, all totaling 223 pages in support of your direct testimony?
Yes, I sponsored those exhibits in support of my testimony.
And your joint DEC DEP exhibit 9 was amended and refiled, or I guess it was just refiled for clarification purposes, and readability purposes on June 16th of 2021, correct?
Yes, that's correct.
And subject to that refiling of DEC DEP joint exhibit 9, do you have any changes to those exhibits at this time?
No, I don't.
All right, Mr. Chairman, I would ask that Mr. Johnson's DEC exhibits 1 through 6, DEP exhibits 1 through 6, and joint DEC DEP exhibits 7 through 10 be marked as the next composite hearing exhibit and accepted into evidence.
Mr. Johnson's DEC exhibits 1 through 6 and DEP exhibits 1 through 6 will be marked and entered into the record as a composite exhibit as hearing exhibit 3. Mr. Johnson's DEC DEP joint exhibits 7 through 9 will be marked as a composite exhibit and entered into the record as hearing exhibit 4.
And Mr. Chairman, just to make clear, I think hearing exhibits 7 through 10 were his joint exhibits.
Yes, sir.
Very good. All right, thank you. All right, Mr. Johnson, did you also cause to be pre-filed in this docket stipulation testimony consisting of 7 pages?
Yes.
And do you have any changes to your stipulation testimony at this time?
No, I don't.
And if I were to ask you the same questions today that appear in your pre-filed stipulation testimony, would the answers remain the same?
Yes.
Mr. Chairman, at this time, I'd ask Mr. Johnson's pre-filed stipulation testimony be entered into the record as if given orally from the stand.
Mr. Johnson's pre-filed stipulation testimony will be entered into the record as if given orally from the stand.
Thank you, sir. And Mr. Johnson, in support of that stipulation testimony, did you also cause to be pre-filed Johnson's stipulation exhibits 1 through 6, totaling 160 pages?
Yes, I did. I sponsored those exhibits in support of my stipulation testimony.
Thank you. And do you have any changes to those exhibits today?
No.
Thank you. Mr. Chairman, I would ask that Johnson stipulation exhibits 1 through 6 be marked as the next composite hearing exhibit and be accepted into evidence.
Johnson stipulation exhibits 1 through 6 will be marked as a composite exhibit and entered into the record as hearing exhibit 5.
Thank you, sir. Mr. Johnson, I'd now like to walk through a summary of your direct and stipulation testimony for the commission. Can you start by telling the commission the purpose of your testimony in support of the company's application in this proceeding?
Yes. The purpose of my testimony is to support the non-rate terms and conditions of the company's documents used for contracting with QFs under Act 62. That is the standard offer tariff, the standard offer PPA, standard offer terms and conditions, the large QF PPA, the large QF tariff, and the notice of commitment form. Those documents are largely the same documents approved by the Commission in the 2019 avoided cost proceeding. My testimony explains how these documents are commercially reasonable, consistent with PURPA, and comply with the requirements of Act 62.
And then on pages 6 through 7 of your testimony, you explain why the contracting documents are divided into documents applicable to the standard offer QFs versus what you call large QFs that do not qualify for the standard offer. Can you explain that testimony to the commission?
Yes, Act 62 essentially divides small power producer QFs into 2 groups. those QFs that qualify for the standard offer as defined in Act 62, and those that do not. Under Act 62, standard offer QFs are those QFs whose renewable facilities are 2 megawatts and smaller. The companies refer to QFs that do not qualify for the standard offer as large QFs because they are larger than the 2 megawatt threshold, limiting eligibility under the standard offer.
Thank you, Mr. Johnson. I'd like to briefly walk through each of the documents that you're supporting in compliance with or in support of the company's compliance with Act 62, beginning with the standard offer. Can you please give the commission an overview of the standard offer tariff as you present on pages 7 through 9 of your testimony?
Yes. The company's standard offer tariffs set forth the company's avoided cost rates and contract terms available to standard offer QFs desiring to sell energy and capacity to DEC and DEP under PURPA. Act 62 requires each utility's avoided cost methodology to fairly and accurately account for cost avoided by the utility or incurred by the utility, including but not limited to energy capacity and ancillary services provided by or consumed by small power producers. The standard offer tariffs address each of those factors, comply with the requirements of PURPA, Act 62, and the Commission's orders in the 2019 avoided cost proceeding.
Thank you. Can you now describe your testimony on the standard offer power purchase agreement and the standard offer terms and conditions as discussed on pages 9 through 12 of your testimony?
Yes, the standard offer PPA is the pro forma PPA that the companies use to contract with smaller QFs eligible for the standard offer for the purchase of energy and capacity under PURPA. The terms and conditions are incorporated into the standard offer PPA by reference and set forth the contractual obligations of both the QF and the companies as necessary to administer the schedule PP and the standard offer PP in a fair and consistent manner. The only changes to the standard offer PPA and the standard offer terms and conditions from the previous versions approved by the Commission in the 2019 avoided cost proceedings are the designations in the header and footer of the respective documents.
Thank you. I now ask you to turn to your testimony on the standard form large QF PPA. Can you please describe that testimony as presented on pages 12 through 17 of your pre-filed testimony?
Yes, the large QF PPA is the standard form PPA that the companies will use to contract with smaller power producer QFs greater than 2 megawatts in size and not eligible for the standard offer that commit to sell and deliver energy and capacity to the companies over a future specified term under PURPA. Act 62 provides that form PPAs for QFs that are not eligible for the standard offer should not be determinative of the avoided cost price or contract length, but requires utilities form PPAs to contain a variety of commercial terms and conditions, including but not limited to provisions addressing force majeure, indemnification, choice of venue, and confidentiality. The company's large QF PPA includes provisions that address each of those requirements, and the documents are also consistent with applicable FERC regulations and orders implementing PURPA, as well as the Commission's orders in the 2019 avoided cost proceeding.
And did the companies make any specific changes to the standard form large QF PPA and the forms the Commission approved in order numbers 2019-881A and 2020-315A, which were the 2019 avoided cost orders that you mentioned earlier?
Yeah, there were a few limited modifications to the large QF PPA to incorporate certain accommodations that have been requested by QFs engaged in the contracting process using this document over the past 18 months. Specifically, the definition of change of control was modified to remove transfers typically done in connection with tax equity financing transactions where the seller retains operational control. In addition, there was also an exception to the change of control definition that was added that allows for lenders to take over control of the facility under foreclosure. Also, there were certain representation and warranties that have been modified relating to eligible commercial entity and eligible contract participant to allow QF sellers additional flexibility for their representation to be effective as of the commercial operation date versus the contract execution date. Section 4.3 was also modified to extend the testing period to allow QF sellers additional time to complete testing, where the delay in obtaining a final permit to operate was caused by the companies and which is not the result of the QF sellers' acts or omissions. The companies are going to continue to negotiate modifications to the large QF PPA to meet individual needs of the QF and to offer all QFs fair and non-discriminatory terms and conditions that appropriately protect ratepayers.
Thank you, Mr. Johnson. Could you now please provide the Commission an overview of the large QF tariff, which you address on pages 17 through 19 of your testimony?
Yes. In the 2019 avoided cost order on reconsideration, the Commission directed the companies to prepare and file a tariff that is similar in structure to the standard offer, but applies to large QFs. Consistent with this requirement, the companies each developed a large QF tariff, presenting the current avoided cost rates available to large QFs. The rates in the company's large QF tariff have been updated quarterly since May 15th of 2020, per the Commission's instruction to incorporate the most up-to-date inputs. The companies will continue updating these rates on a quarterly basis.
Thank you. And the last document you provided or mentioned in your overview was a notice of commitment form. Can you please provide the Commission an overview of the notice of commitment form as presented in your testimony?
Yes. The company's notice of commitment form is a document that small power producer QFs may execute to establish a non-contractual, legally enforceable obligation to sell the output of their QF facility to DEC or DEP as provided for in Act 62. The companies did make one minor modification to the notice of commitment form that the Commission approved in the 2019 avoided cost proceeding. It removes the option to submit the form by mail. This change recognizes that email is a more expedient way to ensure prompt receipt of the document, a concern that became especially apparent during the COVID-19 pandemic.
Thank you, Mr. Johnson. I'd now like to turn to your stipulation testimony and provide the Commission a brief summary of that. Can you please identify which portions of the stipulation you support in your testimony?
Yes, my stipulation testimony presents DEC's updated standard offer tariff, or Schedule PP, and updated large QF tariff, which were both updated to reflect the adjustment to DEC's avoided cost capacity rates as agreed to in the stipulation, and as Witness Snyder just discussed. I also describe amendments to DEC and DEP's large QF PPA.
All right. And can you please describe the updates to the standard offer tariff and large QF tariff that were filed with your stipulation testimony?
Yes. As Witness Snyder explained, the stipulating parties recommend one adjustment to DEC's avoided cost rates to adopt ORS Witness Ori's position regarding the seasonal allocation of capacity value.
All right. And then turning to the large QF PPA that you filed with your stipulation testimony, can you please address that update to the large QF PPA?
Yes. The stipulating parties agreed to make two limited modifications to the large QF PPA, which are presented in track changes in my stipulation Exhibit 5. First, amendments to section 1.13 and new section 1.17 clarify certain actions that a QF seller may take under the large QF PPA without triggering a change of control. Second, Section 5.1 was modified to make limited word corrections to the terms upgrade and requested interconnection facilities in service date.
Thank you, Mr. Johnson. And does the stipulation also address the notice of commitment form?
Yes, the companies and CCDA commit to negotiate in good faith on revisions to the DEC and DEP notice of commitment form. And in particular, the standard for establishing a legally enforceable obligation as reflected on that form. In light of changes to the South Carolina generator and interconnection procedures and Appendix Duke CS approved by the Commission in order numbers 2021-439 on June 18 of 21.
All right. And in your view, does the stipulation result in rates and tariffs that are reasonable and consistent with the requirements of PURPA and Act 62?
Yes.
Thank you, sir. Mr. Chairman, Mr. Johnson is now available for questions, I presume just from the commission per our discussion earlier.
You're absolutely right, sir. Commissioner questions. Mr. Johnson, I'd just like to say it's good to see you all working on ensuring that issues with LEOs are addressed in the appropriate manner. If there are no more questions or comments, Mr. Johnson, you may step down.
Thank you.
I don't think anyone would object for us to take our lunch break a little early. We'll be back at 1:30. We're in recess until 1:30.